The Age Discrimination in Employment Act makes it unlawful for an employer to discriminate against workers due to age. The United States Supreme Court clarified what this means to mandatory retirement policies in Western Airlines v. Criswell. Western Airlines operated large aircraft, such as the DC-10, that required 3 crew members in the cockpit. The pilot and first officer flew the plane. The flight engineer monitored an instrument panel. The Federal Aviation Administration prohibited anyone over the age of 60 from serving as a pilot or first officer on a commercial flight. The FAA justified this requirement by citing the increased risk of medical events that occurs with age and the impossibility of predicting when a sudden emergency might occur. The FAA didn't impose a similar mandatory requirement age on flight engineers on the ground, that engineers don't have the same responsibility for operating the airplane. Western required all flight crew members, including flight engineers, to retire at 60. Charles Criswell and Rulon Starley were pilots who flew DC-10s for Western. Criswell and Starley applied to become flight engineers, but Western denied this request, citing the company's retirement plan. Criswell, Starley, and flight engineer Albert Ron were all required to retire when they turned 60. Criswell, Starley, and Ron sued Western for age discrimination. Western argued that age was a bona fide occupational qualification that affected the safe transportation of passengers, and mandatory retirement based on age was therefore permitted by the Age Discrimination in Employment Act. The jury found for the crew members. The Ninth Circuit affirmed. The United States Supreme Court granted cert.